Legislation and human rights. Equality Act 2010. The Equality Act 2010 is a key piece of legislation in the UK that protects individuals from discrimination and promotes fairness in access to services, education, employment, housing, and public life. It is especially important for people with learning disabilities or autism, as it ensures they are legally protected from unfair treatment and entitled to adjustments that support their inclusion and dignity. The Equality Act 2010 consolidates and replaces over 100 previous laws, including the Disability Discrimination Act 1995, to provide a single, coherent legal framework that protects individuals from unfair treatment in areas such as education, employment, healthcare, and public services. For people with learning disabilities or autism, this act is especially important as it legally recognizes disability as a protected characteristic, thereby placing enforceable duties on care providers, local authorities, employers, and public services to promote inclusion, respect, and equality. Definition of disability under the Act. Under the Equality Act, a disability is defined as a physical or mental impairment that has a substantial and long-term adverse effect on a person's ability to carry out normal day-to-day activities. This includes autism as a neurodevelopmental condition, learning disabilities such as Down syndrome, global developmental delay, or intellectual disability, other neurodivergent conditions such as ADHD and dyspraxia. This means individuals with these diagnoses are legally protected from discrimination and entitled to adjustments that enable fair access to services and opportunities. Protected characteristics. The Act identifies 9 protected characteristics. It is unlawful to discriminate against someone on the basis of any of these. 1. Disability. Covers physical and mental impairments, including autism and learning disabilities, where the condition has a substantial and long-term impact on daily life. 2. Age. Protects individuals of all ages from age-based discrimination or stereotyping. 3. Race. Includes ethnicity, nationality, skin color, and national origin. 4. Sex. Protects both men and women from unequal treatment based on gender. 5. Gender reassignment. Covers individuals undergoing, intending to undergo, or who have undergone gender transition. 6. Sexual orientation. Covers individuals attracted to the same sex, opposite sex, or both. 7. Religion or belief. Includes religious faiths and philosophical beliefs, for example, humanism, and also protects those with no religion. 8. Pregnancy and maternity. Protects women during pregnancy and the period after childbirth. 9. Marriage and civil partnership. Protects individuals in legally recognized unions, mainly in the workplace. These characteristics are vital for understanding how discrimination may occur, especially when a person holds more than one protected status. For example, a black woman with autism may face multiple, intersecting forms of discrimination, racial, disability-related, and gender-based. Types of discrimination covered. The Equality Act protects against direct discrimination, treating someone unfairly because of their disability, for example, refusing service based on a diagnosis. Indirect discrimination, applying a rule or policy that disadvantages disabled people unless it can be justified, for example, requiring complex online forms to access a service. Harassment, behavior that creates a hostile or degrading environment. Victimization, retaliation for making or supporting a discrimination claim. Disability and reasonable adjustments. The Equality Act places a specific duty on organizations to make reasonable adjustments for disabled people. This duty is anticipatory, meaning services must plan ahead to remove barriers before someone asks. Reasonable adjustments may include providing easy-read care plans or appointment letters, offering extended appointment times for individuals who need more processing time, creating sensory-friendly environments, for example, dimming lights or reducing noise, allowing the presence of a carer, support worker, or advocate during appointments, using communication tools like Mercaton, PEX, or social stories. Failure to provide such adjustments can be considered discriminatory. Public Sector Equality Duty (PSED). Public authorities, including health and social care providers, are also bound by the Public Sector Equality Duty, which requires them to eliminate unlawful discrimination, advance equality of opportunity, foster good relations between people with and without protected characteristics. This means services must not only respond to individual needs but also review policies, practices, and training to ensure systemic inclusion. Implications for care workers. Care workers must be aware of the 9 protected characteristics. Understand how discrimination might manifest in daily practice. Promote inclusive care that respects identity, background, and needs. Raise concerns when barriers to equality are observed. Knowing the Equality Act is not only about legal compliance, it's about respecting the human rights and dignity of those we support. Mental Capacity Act 2005. The Mental Capacity Act (MCA) 2005 is a vital piece of legislation in England and Wales that provides the legal framework for making decisions on behalf of individuals aged 16 and over who may lack the capacity to do so themselves. It applies to decisions about health, welfare, finances, and day-to-day care. The MCA is particularly relevant when supporting people with learning disabilities, autism, dementia, or brain injuries. Key principles. The MCA is underpinned by 5 core principles that all care workers must follow. 1. Presumption of capacity. Every adult has the right to make their own decisions unless proven otherwise. 2. Support to make decisions. A person must be given all practicable help before concluding they lack capacity. 3. Right to make unwise decisions. Making an unwise choice does not mean the person lacks capacity. 4. Best interests. Any decision made on someone's behalf must be in their best interests. 5. Least restrictive option. Chosen action should interfere as little as possible with the person's rights and freedom. Assessing capacity. Capacity is assessed in relation to a specific decision at a specific time. A person lacks capacity if they cannot understand the information relevant to the decision, retain that information, use or weigh up the information, communicate their decision by any means. Best interests and legal safeguards. When a person lacks capacity, decisions must reflect their values, preferences, and past wishes. Consultation with family, carers, or advocates is required. The least restrictive option must always be considered. Legal tools under the MCA include lasting power of attorney (LPA), Court of Protection, Independent Mental Capacity Advocates (IMCAs). Implications for care workers. Care workers must ensure consent is sought when a person has capacity, and if not, decisions must be properly recorded and justified. Following the MCA protects both the individual and the worker, ensuring care is lawful, ethical, and person-centered. Human Rights Act 1998. The Human Rights Act 1998 incorporates the European Convention on Human Rights (ECHR) into UK law, meaning that individuals can defend their rights in UK courts and public bodies, such as hospitals, care services, and local authorities, must uphold these rights in everything they do. This law is crucial for people with learning disabilities and autism, who are more likely to face situations where rights may be unintentionally restricted or overlooked. Key rights relevant to care work. Article 2, Right to Life. Public authorities must not only avoid unlawful killing but also take positive steps to protect life, including safeguarding vulnerable individuals. Article 3, Freedom from torture and inhuman or degrading treatment. Care must never involve abuse, neglect, or degrading treatment. Poor care environments or lack of support can breach this right. Article 5, Right to liberty and security. People must not be detained without lawful justification. This is particularly important in settings where individuals may lack capacity and be subject to restrictions under frameworks such as the Deprivation of Liberty Safeguards (DLS). Article 8. Right to private and family life. This covers respect for a person's identity, relationships, communication, and home life. Excessive intrusion or a failure to support independence can infringe this right. Article 14. Protection from discrimination. Human rights must be applied without discrimination on grounds such as disability, age, gender, or race. Responsibilities for care workers. Support individuals to express their preferences and choices wherever possible. Avoid restrictive practices unless absolutely necessary and legally justified. Report concerns about neglect, abuse, or inappropriate care environments. Promote inclusion and dignity in everyday care tasks. Practical application. Care workers may not be legal experts, but they play a critical role in protecting the human rights of those they support. For example, using clear communication tools to ensure understanding respects Article 8, while supporting someone to maintain contact with family protects their right to family life. The Human Rights Act provides a baseline for ethical, person-centered practice, reminding all workers that every individual, regardless of ability, is entitled to dignity, freedom, and respect. Mental Health Act 1983. The Mental Health Act 1983, as amended by the 2007 Act, is the main legal framework in England and Wales for the compulsory treatment of individuals with a mental disorder, including detention, treatment, and community orders. While it is distinct from legislation covering learning disabilities and autism, it does apply in certain situations and should be clearly understood by care workers. When can someone be detained? An individual may be detained under the Act if they have a mental disorder that requires assessment or treatment in hospital. They pose a risk to themselves or others. Detention is necessary and no less restrictive alternatives are available. Detention is authorized through specific sections. Section 2, for assessment up to 28 days. Section 3, for treatment up to 6 months, renewable. Section 136, for emergency removal from a public place by police. Learning disability alone does not justify detention unless it is accompanied by abnormally aggressive or seriously irresponsible behavior, and considered to fall within the legal definition of mental disorder. Safeguards and rights. While detained, individuals are entitled to regular review of their detention, legal representation and the right to appeal, independent mental health advocate IMHO support, respect for their dignity and autonomy as far as possible. Implications for care workers. Care workers may support people who are currently detained under the Mental Health Act, are under community treatment orders (CTOs), have been discharged but need follow-up care or support in the community. Their responsibilities include understanding the person's legal status and restrictions, supporting engagement with treatment and recovery plans, monitoring for signs of distress or relapse, promoting the least restrictive options in care. Relevance to autism and learning disabilities. Individuals with autism and those with learning disabilities may be detained inappropriately if misdiagnosed or misunderstood. The ongoing reform of the Mental Health Act aims to strengthen protections and ensure that detention is used only when absolutely necessary. Care workers play a key role in advocating for rights, alternatives, and ethical care, ensuring that compulsory measures are used fairly and lawfully. Children and Families Act 2014. The Children and Families Act 2014 is a wide-reaching piece of legislation that strengthened the rights of children, young people, and families, particularly those with special educational needs and disabilities (SEND). It places a strong emphasis on early intervention, joint working, and person-centered planning. For care workers supporting children or young adults with learning disabilities or autism, this Act provides the legal basis for delivering holistic and inclusive support. One of the most significant reforms under the Act is the replacement of statements of SEN with education, health and care (EHC) plans. These plans are designed to bring together a child's educational, medical, and social care needs into one unified document. EHC plans cover individuals from birth to age 25 and must involve the child or young person, as well as their family, in decision-making at every stage. The Act also introduced a duty on local authorities to publish a local offer, clearly outlining the services available in their area for children and young people with SEND. This promotes transparency and helps families make informed choices. Importantly, the Act supports the concept of personalization, giving families more control through personal budgets and direct payments. This enables them to tailor services to their child's unique needs and preferences. Care workers must work closely with families, schools, and health professionals to support the aims of EHC plans, advocate for appropriate services, and help children develop skills for independence. The Act reinforces the principle that children's views matter, and their aspirations should guide the planning and delivery of support. In summary, the Children and Families Act 2014 lays the foundation for joined-up, inclusive support, placing children and their families at the center of the system. Care Act 2014. The Care Act 2014 is a major piece of legislation in England that reformed the adult social care system, placing individuals and their well-being at the center of care planning and delivery. It applies to adults aged 18 and over, including those with learning disabilities, autism, physical impairments, or long-term health conditions. The Act sets out legal duties for local authorities and care providers and defines what good care should look like in practice. A cornerstone of the Act is the well-being principle. Local authorities must promote an individual's well-being in all decisions about care and support. This includes personal dignity, protection from abuse and neglect, physical and mental health, participation in work, education, and social relationships, and control over day-to-day life. One of the most important aspects of the Act is the duty to assess needs. Any adult who appears to require support is entitled to a care needs assessment, regardless of their financial status. Carers also have the legal right to their own assessment if they provide regular unpaid care. The Act emphasizes prevention and early intervention, aiming to reduce the need for long-term care by offering support before a person's situation deteriorates. It also introduces the concept of personalization, enabling individuals to take more control over their support through personal budgets and direct payments. Other key elements include the right to an independent advocate if a person has difficulty understanding or engaging in the care process. Legal protection for people under safeguarding concerns, with clear procedures to prevent abuse and neglect. A requirement for integrated working between health, housing, and social care services. For care workers, the Act provides a framework that supports rights-based, person-centered practice. It reinforces the idea that people with learning disabilities or autism should be supported to lead independent, fulfilling lives, with services tailored to their individual needs and preferences. CQC Regulation 18, Staffing. Regulation 18 of the Health and Social Care Act 2008 Regulated Activities Regulations 2014 sets out clear legal expectations regarding staffing in health and social care settings. Regulated by the Care Quality Commission CQC, this regulation ensures that care providers have sufficient numbers of suitably qualified, competent, skilled, and experienced staff to meet the needs of the people using their services. This regulation directly affects the quality, safety, and dignity of care delivered to individuals, particularly those with learning disabilities, autism, or complex support needs. It is one of the key criteria inspected by the CQC during service assessments. Key requirements under Regulation the 18th. 1. Core requirement, Regulation 18(1). Sufficient numbers of suitably qualified, competent, skilled and experienced persons must be deployed in order to meet the requirements of this part. What this means in practice. Please follow the table. 2. Staff support, training and supervision, Regulation 18(2)(a). Person's employee must receive such appropriate support, training, professional development, supervision, and appraisal as is necessary. Key expectations. Induction. New starters complete a structured induction, for example, care certificate before working unsupervised. Training plan. Identify learning needs on appointment and review them regularly. Specialist competence. All staff receive role-appropriate training on learning disability and autism. Supervision. Provide ongoing managerial or clinical supervision until competence is demonstrated and then at agreed intervals. Appraisal. Conduct annual appraisals, set objectives, and record agreed development actions. Monitoring. Keep accurate training records and act promptly where mandatory training or supervision is overdue. 3. Access to further qualifications, Regulation 18(2)b. Providers must enable staff to obtain any additional qualifications required for their role, whether that is advanced care courses, leadership training, or accredited programs. Organizations must not obstruct staff who seek qualifications that enhance the safety and quality of care. 4. Maintaining professional registration, Regulation 18(2)c. Where a post holder is registered with a statutory regulator NMC, HCPC, SWE, GMC, etc. Providers must facilitate revalidation and continuing professional development CPD. Retain systems that alert managers to upcoming CPD or revalidation deadlines. Support staff to join accredited voluntary registers where relevant. Refrain from any action that could prevent staff from meeting regulatory requirements. 5. Enforcement and registration. Registration. CQC must refuse registration if providers cannot show they will comply with Regulation 18 on an ongoing basis. Inspection. Evidence reviewed includes rotas, dependency tools, training matrices, supervision logs, and appraisal records. Regulatory action. Non-compliance may lead to requirement notices, warning notices, conditions on registration or cancellation. 6. Why Regulation 18 matters. For people with learning disabilities and autism, safe staffing is central to consistent communication and reduction of distress, timely identification of health or safeguarding concerns, meaningful activities and community inclusion rather than task-centered care, respecting rights and dignity by avoiding unnecessary restrictions or missed support. 7. Key takeaways for providers and staff. Plan, evidence, and review staffing numbers and skill mix. Embed induction, specialist training, supervision, and appraisal into everyday practice. Support further qualifications and protect professional registration. Document everything. If it isn't recorded, CQC will assume it did not happen. View Regulation 18 as a quality standard, not a paperwork exercise. It underpins every other fundamental standard and directly affects the safety and experience of those you support. Consequences of non-compliance. If a provider fails to comply with Regulation 18, the CQC can issue requirement notices, warning notices, or impose conditions on registration. Services may be rated inadequate or requires improvement. In serious cases, registration can be suspended or cancelled. Responsibilities for care workers. Care workers play a vital role in meeting this regulation by taking responsibility for maintaining their own competence, attending mandatory training and refresher courses, engaging in supervision honestly and reflectively, reporting concerns about unsafe staffing or inadequate training. CQC Regulation 18 ensures that staffing in care settings is not only sufficient in number but also equipped in skill. For individuals with learning disabilities and autism, this regulation safeguards their right to receive safe, compassionate, and tailored care from confident, competent professionals. Thank you. You have successfully made it to the end of this module.